Chapter 4 Legislative Field Distribution of Legislative Powers. The Constitution Acts in force before 1919 provided only for a unitary system of government, and the question of distribution of legislative powers as between the various local governments and the central government did not arise. Section 45A of the Government of India Act 1919, read with Section 129A of that Act, empowered the Governor General in Council with the sanction of the Secretary of State in Council to make rules providing for the classification of subjects in relation to the functions of government as central and provincial subjects for the purpose of distinguishing the functions of local governments and local legislatures from the functions of the Governor General in Council and the Indian legislature. The devolution rules made under Section 45A provided for the classification of subjects into two categories, central and provincial. There was no concurrent list as such. Any matter not included in the central subjects or the provincial subjects was treated as a central subject. See item 47 of Part 1 of Schedule 1 to the devolution rules. Notwithstanding the division of powers, Section 84(2) of the 1919 Act conferred powers on the central legislature to legislate in relation to a provincial subject and powers on the local legislature to legislate in relation to a central subject. The classification of the subjects in the devolution rules formed the basis for three lists set out in the 7th schedule to the Government of India Act 1935. The Constitution adopted the three lists with modifications. The Union list consists of 97 entries, of which 12 entries relate to taxation. The state list consists of 65 entries, of which 19 entries relate to taxation. The concurrent list consists of 47 entries, and the only entry which may be said to relate to taxation is that dealing with stamp duties other than duties or fees collected by means of judicial stamps. The residuary power of legislation and taxation is vested in the Union. Parliament can legislate on a state subject even under normal conditions without the need for any emergency if the Council of States by the requisite majority authorizes it to do so. Again, if two or more state legislatures authorize Parliament in that behalf, Parliament can legislate on a state subject. A brief survey of the provisions bearing on the subject of the constitutions of some of the major federations may be useful in this context. The Constitution of the United States of America is said to provide for a federal government of enumerated powers. Article 1, Section 8 enumerates the powers of the Congress. The 10th Amendment states that the powers not delegated to the United States by the Constitution, not prohibited by it to the states, are reserved to the states respectively or to the people. The state legislature is competent to enact laws in respect of all matters not delegated to the federal government. The Constitution does not by itself classify any subject as one within the concurrent jurisdiction of both the Congress and the state legislature. The word concurrent occurs for the first time in the 18th Amendment in Section 2. However, the Supreme Court has held that although interstate commerce is within the jurisdiction of the Federation, the states may legislate regarding such matters as pilotage, wharves, harbors, etc., but that they may not take any steps that in effect will operate directly to hinder or regulate the carrying on of interstate commerce itself. In Canada, Section 91 enumerates the exclusive powers of Parliament and vests residuary power also in it. The subjects exclusively assigned to the provinces are enumerated in sections 92 and 93. The only subjects included in the concurrent jurisdiction of both the Dominion Parliament and the provincial legislatures are old age pensions, agriculture, and immigration. See Section 94A and 95. As regards Australia, Section 51 of the Commonwealth Constitution Act enumerates the concurrent powers. Section 52 enumerates the exclusive powers of Parliament. By virtue of Section 107, the state legislatures have, besides the concurrent jurisdiction, the residuary powers of legislation also. In Switzerland, certain matters are exclusively vested in the Confederation, and the cantons deal with other matters, the residuary power being vested in the cantons. The concurrent field includes immigration, quarantine, banking, and agriculture. The committee is of the opinion that it is desirable to constitute a high power commission consisting of eminent lawyers and jurists and elderly statesmen with administrative experience to examine the entries of lists 1 and 3 in the 7th schedule to the Constitution and suggest redistribution of the entries. The committee, however, has examined the question in great detail and its views are set forth below. As already pointed out, the Union List reproduces substantially the entries in the Federal List in the Government of India Act 1935, but some of the items which under that Act were within the jurisdiction of the provincial legislature have now been placed within the exclusive jurisdiction of Parliament. The following items are instances in point. Entry 48 deals with stock exchanges and futures markets. There was no corresponding entry in the 1935 Act. In Dunichand versus Buvela Brothers, 1955 ICSR 1071, the Supreme Court held that legislation relating to futures market fell within entry 27 of List 2, namely trade and commerce, markets, etc. By virtue of the present entry, the Parliament has enacted the Forward Contracts Regulations Act 1952, Central Act 74 of 1952, and the Securities Contracts Regulations Act 1956, Central Act 42 of 1956. The validity of the legislation has been upheld by the Supreme Court in Waverly Jute Mills versus Raymond and Co. AIR 1963 SC 90. Entry 84 empowers Parliament to the exclusion of the state legislatures to enact laws relating to duties of excise on certain articles including medicinal and toilet preparations containing alcohol. This corresponds to entry 45 of the Federal List in the Government of India Act. In that Act, entry 40 of the Provincial List empowered the provincial legislature to levy certain excise duties, whereas under the 1935 Act, a duty on medicinal and toilet preparations containing alcohol could be levied only by the provincial legislature. Under the Constitution, the state legislature cannot levy it, and it is Parliament alone which could levy the same. Granville Austin, in the Indian Constitution, Cornerstone of a Nation, attributes this change to a letter circulated among members of the Constituent Assembly by the Magora Chemical Company Limited of Pune, advocating the assumption of excise duties by the Union because the provincial excise duty on alcohol made it difficult to ship tinctures from one province to another. The author also refers to a footnote to the entry stating that it was included in the Union List to provide for uniform rates of excise duty for the sake of development of pharmaceutical industry. It will be observed from the foregoing that some matters which were within the legislative sphere of the constituent units have now been placed in the union field, completely shutting out the state from having anything to do with those items. It may be interesting to note that even at the time of framing of the Constitution, there was an impression that the legislative lists had got stolen a number of items from the provincial and concurrent lists and put them in the federal list. Unquote. Sir N. Gopalaswamy Iyengar, no doubt, tried to dispel this apprehension by saying that a scrutiny and comparison of the lists with those in the 1935 Constitution would reveal that there was no case where the sphere assigned to the provinces by the 1935 Act had been encroached upon except in one or two stray incidents. 6. The committee is of the opinion that the three lists have to be modified on the lines suggested below. 1. Union list, List 1. Industries declared by Parliament by law to be necessary for the purpose of defence or for the prosecution of war. Unquote. The entry is loosely worded, and it can be contended that it includes even industries which are not directly connected with defense. It is desirable to replace the entry by a more precise description confining it to armament industries proper. Quote 32. Property of the Union and the revenue therefrom, but as regards property situated in a state subject to legislation by the state, save insofar as Parliament by law otherwise provides. Unquote. The entry confers overriding powers on Parliament. Article 285 exempts Union property from the imposition of tax by the state. The committee recommends that this exemption should be repealed. Quote 40. Lotteries organized by the Government of India or the Government of a state. Unquote. It is common knowledge that almost all states are running lotteries. According to the Madras High Court, the state government cannot prohibit the sale within the state of tickets relating to lotteries organized by the government of another state. But the Bombay High Court seems to have taken a contrary view. The lotteries run by state governments stand on a footing different from lotteries organized by private individuals. The proceeds of the lotteries go to augment the revenue resources of the states. It appears reasonable that while lotteries organized by the Union government may continue to remain in the Union list, the lotteries organized by the states may be transferred to the state list. In the light of divergence of judicial opinion, it is necessary to expressly authorize the states to prohibit or regulate any activity in connection with or relating to a lottery organized by the government of another state, and this power may be included in the state list. Quote 48. Stock exchanges and future markets. Unquote. Futures markets was an exclusive provincial subject under the Government of India Act 1935. Stock exchanges deal with matters more or less analogous to negotiate instruments and may, therefore, remain in the Union list. The futures markets deal, in essence, with contracts relating to trade and commerce, an exclusive state item. We recommend the futures markets may be transferred to the state list. Quote 52. Industries, the control of which by the Union is declared by Parliament by law to be expedient in the public interest. Unquote. This entry requires special examination. It's based on entry 34 of the Federal List in the 1935 Act. In pursuance of entry 52, Parliament has enacted the Industries Development and Regulation Act 1951, Central Act 65 of 1951, That act specifies in the schedule the various industries declared by Parliament to be industries whose control by the Union is expedient in the public interest. That schedule has been added to, and the number of industries has been increased from time to time. Besides, there are several acts declaring various industries to be industries the control of which by the Union is expedient in the public interest. To mention a few, the Coffee Act 1942, Central Act 7 of 1942, the Rubber Act 1947, Central Act 24 of 1947, the Indian Power Alcohol Act 1948, Central Act 22 of 1948, the Central Silk Board Act 1948, Central Act 61 of 1948, the Tea Act 1953, Central Act 29 of 1953, the Coir Industry Act 1953, Central Act 45 of 1953, Rice Milling Industry Regulation Act 1958, Central Act 21 of 1958, and the Cardamom Act 1965, Central Act 42 of 1965. The various legislative measures, especially the schedule to Central Act 65 of 1951, have the effect of considerably hampering the industrial progress of the states and destroying their initiative. The committee is of the view, which is supported by the opinion of responsible public men, that the schedule to the 1951 Act contains industries which are not really of national importance. To remedy this defect, no amendment to the Constitution is necessary. All that is necessary is to modify the schedule to the 1951 Act so as to restrict its scope to the industries which are really of national importance. This is one alternative course. But then there are the other statutory enactments mentioned above, and so long as the legislative entry remains in the Constitution, nothing prevents Parliament at some future date from declaring any industry to be an industry of national importance. Entry 52 is vague, and the states have been complaining about the way in which Central Act 65 of 1951 had been enforced and its scope enlarged. The committee recommends that entry 52 should be restricted to industries of national importance or of all India character or to industries with a capital of more than 100 crores of rupees. Court 53, Regulation and Development of Oil Fields and Mineral Oil Resources, Petroleum and Petroleum Products, other liquids and substances declared by the Parliament by law to be dangerously inflammable. 54. Regulation of mines and mineral development to the extent to which such regulation and development under the control of the Union is declared by Parliament by law to be expedient in the public interest. 55. Regulation of labor and safety in mines and oil fields. These entries relate to developmental activities of the states. Parliament need not burden itself with the matters specified in these entries. Regulation of labor may be left to be dealt with by the states themselves. The fact that the labor relates to mines and oil fields makes no difference. We recommend that these three entries may be transferred to the state list. Court 67, Ancient and Historical Monuments and Records, and Archaeological Sites and Remains, declared by or under law made by Parliament to be of national importance. Unquote. It will be clear from this entry, entry 12 of the state list, and entry 40 of the concurrent list, that powers in relation to ancient and historical monuments and archaeological sites and remains have been distributed between the Union and the states as follows. 1. Ancient historical monuments and records and archaeological sites and remains, which are of national importance, are within the exclusive purview of the Parliament. 2. Both Parliament and the state legislatures are competent to enact laws in respect of other archaeological sites and remains. 3. The state is the sole authority competent to deal with ancient and historical monuments and records which are not of national importance. This is a matter which, in the fitness of things, should be assigned to the states. The subject is linked with local history and culture. The state is as much interested in the upkeep and maintenance of ancient monuments as the center, if not more. If the state is made the exclusive authority competent to deal with all ancient and historical monuments and records and archaeological sites and remains, one source of friction and misunderstanding would be removed. A controversy has been going on of late between the state and the center regarding the great temple in Tanjavur. Controversies such as this could be well avoided by transferring the subject to the state list. Court 76, Audit of the Accounts of the Union and of the States, unquote. The draft constitution prepared by the constitutional advisor in October 1947 contained a provision for the appointment of a separate Auditor General for the unit if the legislature of the unit provided for it by law. The drafting committee also included a provision for the appointment of auditors in chief by the units, but the Constituent Assembly omitted the provision relating to the appointment of separate auditors in chief for the units. Audit of the accounts of the state is a matter which should, normally speaking, be left to the state legislature. The state government is subject to rigid financial control, and there seems to be no reason for vesting the power in relation to audit of accounts of the states in Parliament. The audit of the accounts of the states may be transferred to the state list. Court 84, Duties of excise on tobacco and other goods manufactured or produced in India, except A. Alcoholic liquors for human consumption, B. Opium, Indian hemp, and other narcotic drugs and narcotics, but including medicinal and toilet preparations containing alcohol or any substance included in subparagraph B of this entry. We have already referred to the circumstances in which the power to levy excise duties on medical and toilet preparations, which under the Government of India Act 1935 was within the exclusive competence of the provinces, was included in the Union list. It will be interesting to note that even under the 1919 Constitution, these excise duties were placed under the control of the governor, acting with ministers who were in their turn responsible to an elected body. These excise duties are collected by the states, and the entire proceeds are appropriated by them. It's therefore appropriate that the power to levy excise duties on medicinal and toilet preparations containing alcohol, etc., should be transferred to the state list. Code 97. Any other matter not enumerated in List 2 and List 3, including any tax not mentioned in either of those lists. Unquote. We shall deal with this topic after disposing of the state and concurrent lists. In relation to the other entries of the Union list, we are of the opinion that no modification is called for. 2. State list. List 2. No one has suggested that any entry in this list should be transferred to the Union or concurrent list. The state list, although based on the provincial list in the Government of India Act 1935, is not identical with it. Some of the entries in the provincial lists have been taken over either to the Union list are the concurrent list. Some of the entries in the provincial list which have been altered so as to vest the power in the Union to the exclusion of the states are concurrently with the states are mentioned below. Court 8. Intoxicating liquors, that's to say, the production, manufacture, possession, transport, purchase, and sale of intoxicating liquors, unquote. The corresponding entry in the Government of India Act, namely entry 31 of the provincial list, referred to narcotic drugs also. This has now been taken over to the concurrent list in the Constitution. See entry 19. While dealing with the concurrent list, we have recommended that entry 19 of the concurrent list may be transferred to the state list. Quote 18. Land, that's to say, rights in or over land, land tenures, including the relation of landlord and tenant, and the collection of rents, transfer and alienation of agricultural land, land improvement and agricultural loans, colonization, unquote. The corresponding entry in the provincial list, namely entry 21, referred to devolution of agricultural land also. Succession to agricultural land under the Constitution is governed by entry 5 of the concurrent list. Thus, a power which under the 1935 Act was vested in the provincial legislature has now been vested concurrently in Parliament also. In dealing with entry 5 of the concurrent list, we have recommended that the said entry 5 may be transferred in its entirety to the state list. Court 23. Regulation of mines and mineral development subjects to the provision of List 1 with respect to regulation and development under the control of the Union, unquote. Entry 23 of the provincial list in the Government of India Act 1935 included oil fields also. This has now been completely taken away from the state legislature, and Parliament is the sole authority competent to deal with oil fields. Entry 53 of the Union list. Consequent upon our recommendations that entries 53, 54, and 55 of the Union list should be transferred to the state list, entry 23 of the state list may be altered suitably. Quote 51. Duties of excise on the following goods manufactured or produced in the state and countervailing duties of the same or lower rates on similar goods manufactured or produced elsewhere in India. A. Alcoholic liquors for human consumption. B. Opium, Indian hemp, and other narcotic drugs and narcotics, but not including medicinal and toilet preparations containing alcohol or any substance included in subparagraph B of this entry, unquote. The state legislature is not competent to levy excise duties on medicinal and toilet preparations containing alcohol. This point has been dealt with in relation to entry 84 of the Union list. Entry 51 of the state list may be altered so as to empower the state to levy excise duty on medicinal and toilet preparations containing alcohol, etc. New entry. A new entry may be inserted in the state list relating to inquiries and statistics for the purpose of any of the matters in the state list. Under the Government of India Act 1935, inquiries and statistics for the purpose of any of the matters in the provincial list were within the exclusive jurisdiction of the provinces. See entry 38 of the provincial list. 3. Concurrent list, list 3. The concurrent list is a reproduction of the concurrent list in the Government of India Act 1935 with some additions. The white paper setting out the proposals of the British government on the eve of the enactment of the 1935 Constitution, and the report of the Joint Committee of the British Parliament justified the inclusion of a concurrent list on the ground that it was being inserted in order to secure uniformity in legislation. The concurrent list in the Constitution has reproduced, with substantial additions, the concurrent list in the 1935 Act. During the consideration of the concurrent list by the Constituent Assembly, it was further enlarged by the transfer of certain subjects from the state list or by fresh additions. Through K. Santhanam protested in the Constituent Assembly against this expansion of the concurrent list. Even assuming that there is need for a concurrent list, it will be noticed that there are several items in that list which, under the 1935 Act, were included in the provincial list. They are examined below. The concurrent list should be confined to entries which are of interest to the country as a whole or of an all India base, and the other entries should be transferred to the state list. The following are our recommendations in respect of concurrent list. Court 5. Marriage and divorce, infants and minors, adoption, wills, intestacy and succession, joint family and partition, all matters in respect of which parties in judicial proceedings were immediately before the commencement of this Constitution subject to their personal law. Unquote. It has already been pointed out when dealing with entry 18 of the state list that succession to agricultural land under the 1935 Act was within the exclusive sphere of the provincial legislature. This has now been made a concurrent subject. Personal law varies from region to region, and it will make for better administrative efficiency if the subject is dealt with by the state themselves without interference by Parliament. In this view, we recommend that this entry may be transferred in its entirety to the state list. Quote 8. Actionable wrongs, unquote. The corresponding entry in the concurrent list in the 1935 Act, namely entry 14, excluded actionable wrongs included in laws with respect to a matter in the provincial list from the purview of Parliament. In other words, only actionable wrongs included in laws falling within the concurrent list were placed under the jurisdiction of the federal legislature and that of the unit legislatures. This entry may be transferred to the state list. Quote 17. Prevention of cruelty to animals, unquote. This was no doubt included as entry 22 of the concurrent list in the Government of India Act 1935, but this relates to purely local problems and the entry may be transferred to the state list. Quote 19. Drugs and poisons subject to provisions of entry 59 of list 1 with respect to opium, unquote. As pointed out in relation to entry 8 to the state list, narcotic drugs was within the provincial field. Entry 19 may be transferred to the state list. Quote 22. Trade unions, industrial and labor disputes. 23. Social security and social insurance, employment and unemployment. 24. Welfare of labor, including conditions of work, provident funds, employers' liability, workmen's compensation, invalidity and old age pensions, and maternity benefits. 25. Vocational and technical training of labor. These relate to social welfare and organization of labor. Questions arising out of these matters have to be decided by the authorities of the state, and even acts passed by Parliament in relation to these matters have to be enforced through the agency of the state authorities. These entries may therefore be transferred to the state list. Cot 28. Charities and charitable institutions, charitable and religious endowments and religious institutions. Unquote. We wish to point out here that even under the 1919 Constitution, the subject matter of this entry, which was in the provincial field, was entrusted to the transferred half of the government. That is, it was a subject to be administered by the governor acting with ministers responsible to the legislature. This was purely a provincial subject under the 1935 Constitution. See entry 34 of the provincial list. This state has always taken a keen interest in the regulation of charitable and religious endowments. A comprehensive legislation on the subject enacted in 1926 was subsequently replaced by a separate act in 1951, which in its turn was repealed and reenacted in 1959. The Government of India appointed a commission under the chairmanship of late Sir C.P. Ramasamy Iyer to inquire into the conditions of religious endowments, and based on the recommendations of the commission, a draft bill was introduced in the Lok Sabha. It will be seen that a subject which was within the exclusive sphere of the constituent units has now been taken over to the concurrent list, and this is an instance where the union has been trying to take on its shoulders a burden which should normally be left to the states themselves. This entry may be transferred to the state list. Cot 30. Vital statistics including registration of births and deaths. Unquote. Under the 1935 Constitution, registration of births and deaths was the exclusive concern of the provinces. Entry 14 of the provincial list. Statistics for the purposes of the provincial list was also within the exclusive competence of the provinces. Entry 38 of the provincial list. We had a separate act in the state dealing with registration of births and deaths, namely the Tamil Nadu Registration of Births and Deaths Act 1899, Tamil Nadu Act 3 of 1899. This has now been repealed by the Registration of Births and Deaths Act 1969, Central Act 18 of 1969. This is another instance of an exclusive state subject being taken over to the concurrent field. As regards the vital statistics, attention is invited to the Collection of Statistics Act 1953, Central Act 32 of 1953. This act also deals with a subject which, under the 1935 Constitution, was within the exclusive sphere of the provinces. As in the case of religious and charitable institutions, the subject matter of this entry also was in the category of transferred subjects under the 1919 Constitution. It may be transferred to the state list. Cot 31. Ports other than those declared by or under law made by Parliament or existing law to be major ports. Unquote. Minor ports was within the exclusive competence of the provinces under the 1935 Act. See entry 18 of the provincial list. Under the Constitution, major ports are within the union field and minor ports have been placed in the concurrent field. Minor ports may be transferred to the state list. Cot 32. Shipping and navigation on island waterways as regards mechanically propelled vessels, and the rule of the road on such waterways, and the carriage of passengers and goods on island waterways, subject to the provisions of List 1 with respect to national waterways. Under Cot, This entry corresponds to entry 32 of the Concurrent List in the 1935 Act, with the difference that there is no reference to national waterways in the 1935 Act. That's to say, the power conferred on the provincial legislature by entry 32 of the Concurrent List in the 1935 Act was not subject to the power of the central legislature to deal with national waterways. Under the Constitution, the power of the state legislature will be subject to the power of Parliament in relation to national waterways. Inland waterways constitute internal means of communication along with roads. We recommend that this entry may be transferred to the state list. Quote 33. Trade and commerce in and the production, supply, and distribution of a. The products of any industry where the control of such industry by the Union is declared by Parliament by law to be expedient in the public interest, and imported goods of the same kind as such products. B. Foodstuffs including edible oil, seeds, and oils. C. Cattle fodder including oil cakes and other concentrates. D. Raw cotton, whether ginned or unginned, and cottonseed. And E. Raw jute. 34. Price control. Unquote. These are matters which, under the 1935 Act, fell under entries 27 and 29 of the provincial list. The matters referred to in items 33 and 34 may well be transferred to the state list without any serious detriment to the national interest. Quote 35. Mechanically propelled vehicles, including the principles on which taxes on such vehicles are to be levied. Unquote. In the Government of India Act 1935, as originally enacted, entry 20 of the concurrent list referred only to mechanically propelled vehicles, but not to taxes thereon. It was by Section 3(2) of the India and Burma Miscellaneous Amendments Act 1940, 3 and 4, Geo 6, Chapter 4, that a new entry, namely entry 48A, was inserted in the provincial list in the 1935 Act, empowering the provincial legislature to impose taxes on vehicles suitable for use on roads, whether mechanically propelled or not, including tram cars. Entry 57 of the state list in the Constitution corresponds to entry 48A of the provincial list in the 1935 Act. But whereas entry 48A was an independent provision which could be pressed into service by the provincial legislature without being subject to any restriction or limitation, entry 57 of the state list is subject to entry 35 of the concurrent list. Entry 35 of the concurrent list thus includes a subject matter which, under the 1935 Act, was within the exclusive sphere of the units. Moreover, mechanically propelled vehicles are even now controlled by the state governments, although the law relating to them is a central act. The various powers and functions are exercised by the state government and their subordinate officers. We recommend that this entry should be transferred to the state list. Quote 36 factories, 37 boilers, 38 electricity. Unquote. These relate to setting up of industries and other activities relating to the economic development of the states. In our opinion, they should be appropriately included in the state list. 39. Newspapers, books, and printing presses. In a sense, these may be said to relate to public order, a matter included in entry 1 of the state list. Viewed from another angle, they may be said to relate to education also, although in an indirect manner. Yet another aspect of the matter is the publicity value of the newspapers and books. Viewed from any angle, these are matters which vitally concern the states, as in the case of several other matters, including in the concurrent list. In this case, also, the administrative machinery for the enforcement of the laws is that of the states. This entry may, therefore, be transferred to the state list. Quote 40. Archaeological sites and remains, other than those declared by or under law made by Parliament to be of national importance. Unquote. We have dealt with this matter when dealing with entry 67 of the Union list. Entry 40 of the concurrent list may be transferred to the state list. Quote 42. Acquisition and requisitioning of property. Unquote. This was a matter which, under the Government of India Act 1935, was included in entry 9 of the provincial list. In the Constitution, as originally enacted, the subject matter was spread over entry 33 of the Union list, entry 36 of the state list, and entry 42 as it originally stood of the concurrent list. By the Constitution, 7th Amendment Act 1956, entry 33 of the Union list and entry 36 of the state list were omitted, and the existing entry 42 of the concurrent list was substituted for the corresponding previous entry. Before 1956, the substantive power to enact legislation with respect to acquisition and requisitioning was divided between the Union and the state legislatures according to the purpose for which such acquisition or requisitioning was to be made. In other words, the state legislature could not enact a law affecting acquisition or requisitioning for union purposes. Similarly, Parliament could not enact a law affecting acquisition or requisitioning for state purposes. Prior to 1956, for the acquisition or requisitioning of property for the purposes of the Union, it was Parliament alone that was competent to enact the necessary law, and if it was for the purpose of the state legislature had the exclusive jurisdiction. The only matters included in the concurrent list were the principles on which compensation should be determined and the form and the manner in which such compensation was to be given. By the 1956 amendment, the position has been altered radically, and acquisitioning and requisitioning of property, even for the purposes of the state, have now been brought within the concurrent field. It's a matter of common knowledge that the law relating to acquisition and requisitioning of property for the purposes of the Union also is being administered by the state government. We therefore recommend that this subject may be included in the state list. Quote 45. Inquiries and statistics for the purposes of any of the matters specified in List 2 or List 3. We have recommended that a new entry may be inserted in the state list relating to inquiries and statistics for purposes of any of the matters in that list. Consequent upon this recommendation, entry 45 may be confined to matters specified in the concurrent list, the reference to state list being omitted. It will appear from what is stated above that several of the entries in the concurrent list have to be transferred to the state list. The concurrent list is a novel feature of a constitution imported from the 1935 Act. The main grievance of the states about the concurrent list is that Articles 246 and 254 provide for the supremacy of parliamentary legislation over that of the states. In Canada, the concurrent list is a short one, comprising as it does only three subjects. In Australia, no doubt, the concurrent list is a fairly long one, but then the residuary powers of legislation vest in the states. In America, there is no concurrent list as such, although, by virtue of the decisions rendered by the Supreme Court, concurrent powers have been deduced in respect of certain specific matters. The Joint Committee of the British Parliament has itself recognized the fact that the subjects specified in the concurrent field are really provincial in character. Under the 1935 Constitution, there was a safeguard in relation to legislation by Parliament on a concurrent subject. It will be seen from the concurrent list that they were classified into two broad categories. Paragraph 11 of the Instrument of Instructions issued to the Governor General specifically require him to ensure that the provincial governments concerned had been duly consulted before any bill or amendment relating to a matter specified in Part 2 of the concurrent list was introduced in the central legislature. The Constitution does not provide for any such safeguard. The committee is of opinion that such safeguard is necessary. This may be provided by insisting that before any bill is introduced in Parliament in relation to an item in the concurrent list, that states should first be consulted and their views taken into consideration. Such consultation with the states should be in addition to obtaining the remarks of the Interstate Council on the bill. The bill introduced in Parliament should contain a statement showing that such a reference was made. The recommendation, if any, of the Interstate Council and a brief resume of the opinions expressed thereon by the various state governments should also be appended to the bill at the time of its introduction. The following observations of the then Finance Minister of Tamil Nadu in his budget speech dated the 26th of February 1970 forcibly brings out the necessity of the center consulting the states in all matters of national policy, particularly economic policies. Court, the important determinants of economic policy in modern society, which have a bearing on the production apparatus of the states, are banking, currency, and fiscal policy, and these are controlled wholly by the Government of India. It's therefore no accident that very often the government of the state is faced with unfortunate consequences of decisions taken by the center. The recent recession in the country was brought about by monetary and fiscal policies, which reduced effective demand in the country and thus led to a vicious spiral of one industry after another grinding to a halt. At a time at which the country could have gone ahead based on abundance of food production, the economy actually stalled. The textile industry found itself in doldrums, while engineering industries were starved of artists. The pause in planning aggravated the situation further by reducing the level of public investment. The state governments were not consulted in respect of any of these crucial decisions. Again, in the arena of price policy, most of the decisions of the center are made without regard to circumstances obtaining in various states. The price situation in the country reflects, in a large measure, the overall demand and supply. In respect of demand, the central government's monetary policy is an important determinant. As regards supply, an imaginative policy decision by the center to import crucial raw materials such as steel, cotton, staple fiber, and the like at the right time could have stemmed many speculative trends. The state government has been kept in the dark in regard to the rationale behind policies that are adapted at the center from time to time. Residuary powers. The residuary powers of legislation was vested by the Government of India Act 1935 in the Governor General, see Section 104. The important safeguard was that he should exercise these functions in his discretion, which meant that he was not bound to consult the federal ministry, much less was he bound by ministerial advice. In the discharge of functions under Section 104, he was subject to the ultimate control of the British Cabinet and through them to the British Parliament. The Governor General could authorize either the federal legislature or the provincial legislature to exercise the residuary powers with respect to any matter. Under the Constitution, the residuary power of legislation vests in Parliament. Article 248 and Entry 97 of the Union List. And there is no safeguard to protect the interests of the states. With a detailed and elaborate enumeration of the subjects in the three lists, the occasion for the exercise of residuary power and the extent of such power seem to be very limited. The residuary power of legislation and taxation is expressly vested in the units by the constitutions of the United States of America, Australia, and Switzerland. In Canada, Section 91 of the British North America Act no doubt states that the Dominion Parliament may, quote, make laws for the peace, order, and good government of Canada in relation to all matters not coming within the classes of subjects by this Act assigned exclusively to the legislatures of the provinces, unquote. But by virtue of judicial interpretation, particularly by the Privy Council, the present position is stated to be that there are only two separate grants of dominion power. What was once intended to be a residuary power, namely the power to make laws for the peace, order, and good government of the country, has been held to be inoperative in times of peace, and it is stated that the residuary power of the Dominion comes into play only on occasions, notably in times of national peril. It is stated that in ordinary times it's impossible to conceive of any general legislation which does not affect to some degree the property and civil rights in the units, an item in the provincial field, and that the comprehensiveness of the latter has thus filled in almost the whole gap left between the Dominion's enumerated powers and the other enumerated powers of the provinces. It will thus be seen that in all the federations the residuary powers vest in the constituent units. We therefore recommend that the residuary power of legislation and taxation conferred by Article 248 and Entry 97 of the Union List be vested in the state legislatures. Other legislative provisions. As already stated, apart from the legislative list, the articles mentioned below confer independent powers of legislation on Parliament. Article 154 2b. This empowers Parliament to confer functions on authorities subordinate to the governor. The consent of neither the state legislature nor the state government is necessary for this purpose. The remarks in relation to Article 258 2 will apply here also. Article 169(1). This article relates to the abolition and creation of legislative councils in states. It empowers Parliament by law either to abolish a legislative council or create one where it does not exist now. The condition precedent for the exercise of this power by Parliament is the passing of a resolution by the Legislative Assembly of the state concerned. Parliament is not bound to act under this article merely because the Legislative Assembly has passed a resolution to that effect. The composition of the state legislature is a matter to be decided by the people of the state, and the members of the assembly who represent the people may be expected to act in accordance with the wishes of the people. In fact, in the initial stages of the framing of the Constitution, a provision was included in the draft Constitution providing for the introduction of a bill in the state legislature itself for altering the provisions of the Constitution relating to the composition of the state legislature. The draft originally provided that the bill, after being passed by the legislature of the unit, should be ratified by Parliament and the bill presented to the governor for his or President's assent. Subsequently, however, this provision was modified to provide that the assent should be that of the President only. But the bill had to be initiated in the legislature of the unit, and then, after being passed by the unit legislature, had to be ratified by Parliament. In the draft constitution prepared by the drafting committee in February 1948, the provision figured as Article 304 2. According to the draft article, a bill seeking to make any change in the Constitution relating to the number of houses of the legislature of the state had to be initiated in the state legislature itself, and after being passed by it, it had to be ratified by Parliament and assented to by the President. In the United States of America, Switzerland, and Australia, it's the state which determines the number of houses of its legislature, and the federal or general government has nothing to do with the matter. We would, therefore, recommend that Article 169(1) may be so amended as to empower the Legislative Assembly of the state to provide for the abolition or creation of a legislative council. Article 249. There is no precedent for this article in any of the four federations of the traditional type, nor in the Government of India Act 1935. This article had its genesis in the first visit of the constitutional advisor, Sir B.N. Rao, to the United States of America in November 1947. The report of the President's Committee on Civil Rights, published in that country, recommended that the national government must take the lead in safeguarding the civil rights of all Americans, and that the Congress must enact the necessary legislation. Sir B.N. Rao suggested a provision identical with Article 249, so that when legislation on a state subject was called for on a national scale, the central legislature should have power to enact it. He stated that since it was dependent on a majority of the Council of States, it was sufficient to safeguard the interests of the constituent units. Even at the time of the framing of the Constitution, there was considerable opposition to the article. திருவாளர்கள் H.V. Padaskar, O.V. Alagesan, and B.M. Gupta regarded the article as objectionable and inconsistent with the concept of a federal distribution of powers. They thought that it was unnecessary in view of the other provisions in the Constitution. They pointed out that inasmuch as the article enabled Parliament on the strength of a resolution of the Council of States to invade the state list, it was a quote mischievous unquote one. Thiru Jayaprakash Narayan wanted the article to be omitted. The Bombay and East Punjab legislatures regarded it as a grave infringement of provincial rights and favored its omission. Thiru T.T. Krishnamachari, supporting the article, maintained that the units could exercise checks through their representatives in the Council of States, and that there was enough scope for the units through their representatives in the Council of States to tell them that the central powers should not be renewed. It has to be stated here that the Council of States is an indirectly elected body and that the representation of the states is on the basis of population, even here as in the Lok Sabha. The more populous states dominate the Rajya Sabha. There would have been some justification for this article had the states got equal representation in the Council of States, which is not the case. This article seems to militate against the fundamental principle of freedom. The federal principle receives a jolt by the provision made in Article 249 of the Constitution. Article 249, which empowers Parliament to legislate with respect to a matter in the state list if a resolution supported by not less than 2/3 of the members present and voting in the Rajya Sabha approves of such action, is wholly derogatory to the conception of a federation and is a serious inroad into state autonomy. Court, national interest, unquote, is a criterion wide enough to include any matter which concerns the country as a whole. Moreover, the resolution of the Council of States is conclusive as to whether it is expedient in the national interest that Parliament shall legislate with respect to state list matters. It's a radical deviation from the generally accepted notion of federalism to permit a national legislature to transfer to itself unilaterally powers reserved to the states by the Constitution. In the United States of America, Congress cannot formally transfer to itself any of the powers belonging to the states. A constitutional amendment is the sole means. Similar is the case in Australia also. In Canada, under the residuary power relating more particularly to the Court, Peace, Order, and Good Government of Canada, unquote, the Dominion Parliament may legislate on provincial subjects whenever they assume national importance. But this power has been very much circumscribed by judicial decisions. Moreover, it is the judiciary and not the Dominion Parliament which has to determine finally whether a matter has assumed national dimensions. Wide AG Ontario versus Canada Temperance Federation, 1946, AC 193. In India, the Supreme Court has taken the view that the judiciary has no power to decide such questions. Article 249 thus enables the majority in the Rajya Sabha to override the normal distribution of powers. The replies received by the committee favor repeal of the article. It may, therefore, be omitted. Article 252. This is based on Section 103 of the Government of India Act 1935. But there is one material difference between the two provisions. Whereas under section 103, the provincial legislature, which has agreed to legislation by the federal legislature or has adopted the act of the federal legislature, could amend the central act or even repeal it. Under Article 252, the state legislature is expressly prohibited from amending or repealing a central act passed in pursuance of resolutions of the legislatures of two or more states, although the subject matter of legislation is entirely within the state sphere. The drafting committee stated that the article was in conformity with Section 51(37) of the Australian Constitution, read with Section 109 of that Constitution. It may be pointed out that under the Australian Constitution, the power conferred by Section 51 is not exclusive to the Commonwealth Parliament, and that the state legislature also can exercise the power. In other words, any law passed by the Commonwealth Parliament on the strength of Section 51(37) can be amended or repealed by the state legislature. Refer Section 107. We recommend, therefore, that the position as it obtained under the Government of India Act 1935 may be restored. Article 258(2). This is based on Section 124(2) of the 1935 Act. In the United States of America, the federal government cannot transfer to the states, nor can the states transfer to the federal government their respective legislative powers. Such delegation of legislative power is forbidden by the general doctrine that a delegated power may not be delegated. Under the Canadian Constitution, neither the Dominion nor the province can delegate its legislative power to the other. It may be pointed out here that according to Clause 1 of Article 258, before the President entrusts any function to the state, he has to obtain the consent of the state. A similar condition may be laid down in respect of Clause 2 of that article. It may be provided that before Parliament confers powers or imposes duties upon the state or any officer or authority thereof, the consent of the state should be obtained. Reservation of state bills for consideration by President. Incidental to the power of legislation vested in the state is the provision in the Constitution contained in several articles requiring the reservation of certain state bills for consideration of the President. These provisions are dealt with below. Article 31(3) lays down that no law providing for the acquisition or requisitioning of property shall be valid unless it has been assented to by the President. The reason for this provision is not obvious. If the law is within the competence of the state legislature and is consistent with the fundamental rights taken, then it will be valid. Per contra, if the law is outside the legislative competence of the state legislature or is inconsistent with any of the fundamental rights, the assent of the President cannot be pressed into service for sustaining its validity. Greenville-Astin has surmised the reason for this provision thus. Quote, the clause reserving all property legislation for presidential assent must also have been included at Patel's demand, for it meant that so long as he lived, Patel could block any legislation that seemed to him unjust. Quote, the President, unquote, of course, meant the Cabinet, and in the Cabinet Patel had veto power, and Nehru, one presumes, was also not averse to the Union executives having the opportunity to dampen unseemly zeal in the states. Page number 98. Unquote. Article 31 corresponds to Section 299 of the Government of India Act 1935. There was no provision in Section 299 for reserving for consideration of the Governor General or the British Crown bills passed by the provincial legislatures providing for the compulsory acquisition of land, etc. Subsection 3 of the section no doubt stated that no bill or amendment relating to the subject matter should be introduced in the provincial legislature except with the previous sanction of the governor in his discretion. The instruments of instructions issued to the Governor General and the Governor required them that if they felt any doubt whether or not a bill offended against Section 299, the bill should be reserved for consideration by the British Cabinet. See paragraph 13C of the instrument issued in the Governor General and paragraph 17C of the instrument issued to the Governor. This requirement regarding the reservation of bills for assent by the Governor General or the British Cabinet was not part of the 1935 Act. It was an administrative arrangement, and any infraction of the instruments was not justiciable. Nor did such infraction affect the validity of the action of the Governor General or the Governor. See sections 13(2) and 53(2) of the 1935 Act. The reason for the provision in the instruments is to be found in the recommendation of the Joint Parliamentary Committee. That committee stated in paragraph 369 of its report that some general provision should be inserted in the Constitution Act, quote, safeguarding private property against expropriation in order to quiet doubts which have been aroused in recent years by certain Indian utterances, unquote. It therefore recommended that the Governor or the Governor General should be directed by the instrument court to take into account as a relevant factor the nature of the provisions proposed for compensating those whose interests will be adversely affected by the legislation, unquote. It will thus be seen that the requirement that provincial bills relating to acquisition of property should be assented to by the Governor General, and if he had any doubts, by the Crown was inserted in the 1935 Constitution to guard against expropriation of property and with reference to the sentiments expressed by national leaders of this country. The governments, both at the center and in the states, are by and large committed to schemes of socio-economic development without unduly burdening the public exchequer. Again, under the 1935 Act, even if a bill relating to acquisition of property was not reserved for the consideration and assent of the Governor General or the British government, the validity of the relevant act was not open to doubt. Under the Constitution, however, no such law would be valid unless it is assented to by the President. A paper submitted to the National Convention on Union-State Relations, held in New Delhi in April 1970, deals with presidential assent to the state bills. The writers, commenting on Article 31(3), have stated that under that article, the adequacy of the compensation cannot be questioned in courts, and that in the absence of judicial scrutiny, the centre, while giving assent, can ensure that the states do not take away private property without compensation, and that compensation is given on certain uniform principles throughout the country. It has to be mentioned here that in the bank nationalization case, the Supreme Court has categorically stated that it is for the judiciary to go into the question of the adequacy of compensation for property acquired by the state. Even assuming, without granting it, that courts cannot sit in judgment over the legislature's decision regarding the quantum of compensation, it's not clear as to how the scrutiny of the union government will improve matters. As already stated, the validity of the legislation has to be sustained with reference to the competence of the state legislature to undertake it and its consistency with the federal rights. As regards uniformity in the matter of compensation, this could be easily secured through conferences and various other forums, such as the National Development Council. The states have to undertake several legislative measures for improving the social and economic conditions of the masses, and the requirement that in every such case involving acquisition of property, the center should be approached necessarily delays matters. It seems that Article 31.3 may well be omitted. The next article to be considered here is the first proviso to Article 31A.1. Here too, the authors of the paper submitted to the National Convention seek to confer on the state the role of a superior sitting in judgment over a subordinate and trying to pull up the subordinate. The center cannot be fully aware of the local problems in the various parts of the country. As an instance, Article 31A 2, subsection A defines the expression estate and goes on to state that it includes lands held under Rayatwari settlement. Court, it is well known that in Tamil Nadu and Andhra Pradesh, at any rate, so far as the common man is concerned, and even for the purpose of statutory drafting, Rayatwari lands are entirely different from lands comprised in an estate. In this part of the country, the term estate is used in relation to zamindari and inam lands as distinguished from Rayatwari lands. This artificial definition could well have been avoided if only the matter had been left to be dealt with by the state government itself. It will be clear that the authorities in Delhi had failed to recognize the difference between the Rayatwari system of land tenures obtaining in this part of the country and the Zamindari system. Article 31A may be amended so as to dispense with the need for the assent of the President of the bills. Article 200 is an omnibus provision which confers power on the governor to reserve any bill for the consideration of the President. The main part of the article is an enabling one, that's to say, it's merely directive and it's open to the governor either to reserve the bill for the President's consideration or to assent to the bill. The second proviso is mandatory in character and it casts an obligation on the governor to reserve the bill referred to therein for consideration of the President. It will be useful here to refer to Article 201 also. The two articles read together make it clear that when a state bill is reserved by the governor for the consideration of the President, the latter can withhold assent from the bill, and even when the state legislature passes the bill for the second time, the President is under no obligation to assent to the bill. This is in sharp contrast with Article 111, according to which, if the President returns a bill passed by the Parliament for reconsideration and Parliament passes it again, the President has necessarily to assent to it. The President, which means the Central Cabinet, can thus effectively block state legislation if the Central Cabinet chooses it that way. Granville Austin, in dealing with Articles 200 and 201, says, Court, in theory, They invalidate the division of powers, for there is no means of overriding the president's veto in the case of state legislation, unquote, page 207. It follows that, consistent with state autonomy, the power now conferred on the governor to reserve any bill for the president's consideration should be taken away. The second proviso to Article 200 leaves no choice to the governor, and it requires the governor to reserve the bill for the consideration of the president if it is likely to so derogate from the powers of the High Court as to endanger the constitutional position of the High Court. The corresponding provision of the 1935 Act, namely Section 75, did not contain a provision similar to the second proviso to Article 200, but paragraph 13b of the Instrument of Instructions issued to the governor stipulated that any bill which, in the opinion of the governor, would, if it became law, so derogate from the powers of the High Court as to endanger the position which that court was, by the Government of India Act 1935, designed to fill, should be reserved for the consideration of the Governor General. However, Section 53(2) of the 1935 Act expressly laid down that the validity of anything done by the governor should not be questioned on the ground that it was done otherwise than in accordance with the Instrument of Instructions issued to him. It will thus be seen that what was merely an administrative arrangement, not open to judicial scrutiny, has now been elevated to the level of a constitutional mandate, thus affecting the very validity of a legislative enactment undertaken by the state. This provision seeks to confer on the center a paternal role and clothes it with power of overlordship, the very thing which, with the emergence of the governments in the states belonging to different political parties, has to a large extent affected the harmonious relationship between the center and the states. The states are as much interested in maintaining the position and the status of the high courts as the center. Therefore, the second proviso to Article 200 may be omitted. The governor may reserve a bill passed by the state legislature for the consideration of the president. It's nowhere enjoined that the governor, in making such a reference, should act on the advice of his council of ministers, though constitutional experts are of the opinion that the governor has no authority to act on his own. This interpretation is not implicit in the express provisions of the Constitution, nor is any remedy provided if the governor were to act on his own responsibility in making such a reference. It's possible, and in fact it has happened once, that a state of the union comes to be controlled by a party in opposition to the party in power, the center. The legislature of the state is competent to make any law to give shape to the political and economic ideology of the party, so long as it keeps within the demarcated field of its legislative authority. The provisions of the enactment may well be in conflict with the philosophy of the national government. If the governor were to reserve such a bill for consideration of the president, the question would immediately arise: should the president act on his own, or the advice tendered by his council of ministers, or that of the state? If, as has been suggested, the president must act in accordance with the advice tendered by his council of ministers, he may either withhold his assent or ask for a reconsideration in accordance with the message he sends. In other words, the party in power at the center may use presidential veto to discredit the opposition party. The growth of democratic opposition parties in the states may thereby receive a setback and facilitate the continuance of one party rule throughout the territories of India. The important point to note is that no time limit has been prescribed for presidential consideration. He can, if he so desires or is so advised, put the bill into cold storage indefinitely. Secondly, there is no provision for overriding the presidential veto in respect of state legislation. His veto is absolute. It can be on any bill referred to him, nor need he give reasons for exercising the veto. As the President acts on the advice of the Union Executive, the legislative powers of the state may, to a limited extent, be interfered with the use of presidential veto. Thus, in theory as well as in practice, the operation of the state legislative process is subordinate to the supremacy of the Union Executive. The role of the governor in center state relations is a crucial factor. The Constitution nowhere requires that the governor, in reserving a state bill, acts on the advice of his council of ministers. It's true that the governor is the constitutional head of the state. At the same time, the Constitution makes him the nominee of the president. He holds his office at the pleasure of the president, who appoints him on the advice of the prime minister. The governors have been selected mostly from the ranks of the political party in power, and frequently defeated politicians were given the safe haven of gubernatorial posts. Though theoretically the governors are supposed to be politically non aligned, they remain basically partymen watching the political developments in their states. In such a situation, they may not heed the advice of their state cabinet in referring to the president state legislation prejudicial to their party. We recommend that Article 200 and 201 may be repealed. Article 254 2. This article relates to the contrariety that's likely to arise between a central act and a state act when both the acts relate to a concurrent subject. Even the assent of the President to a state act on a concurrent subject does not prevent Parliament from repealing the very state law assented to by the President. In this view, we fail to understand the need for the provision contained in Article 254 2. In the light of our recommendations regarding the interstate council and the placing of all bills to be introduced in Parliament before that council, the question of reserving the bill for the consideration of the President is not likely to arise. In no other federal constitution is there any provision for bills of the unit legislatures being reserved for the consideration of the Union or federal executive. Clause 2 of Article 254 may be omitted. In a federal setup, there is no scope for one of the parties, namely the Union, to act as a sort of guide to ensure compliance with the Constitution. The High Courts and the Supreme Court have been entrusted with this function. All things considered, it may be safely stated that the provision for reservation of state bills for the consideration of the President is a superfluity and may be said to act as an irritant in some cases. All such provisions may be omitted except the provision in Article 288 2. Ordinance making powers of the governor need for previous instructions from the President. Arising out of the provisions in the Constitution requiring the reservation of bills passed by the state legislature for the consideration and assent of the President is the provision prohibiting the governors from promulgating ordinances without instructions from the President in the circumstances specified in the proviso to Article 213 1. According to that proviso, The previous instructions from the President are necessary in the following three contingencies. 1. If a bill containing the same provisions would, under the Constitution, have required the previous sanction of the President for its introduction in the state legislature. 2. The governor would have deemed it necessary to reserve a bill containing the same provisions for the consideration of the President. 3. An act of the state legislature containing the same provisions would, under the Constitution, have been invalid unless assented to by the President. The only provision in the Constitution which requires the previous sanction of the President for the introduction of a bill in the state legislature is the proviso to Clause B of Article 304 relating to trade and commerce. In dealing with this topic, we have suggested the omission of this proviso. It follows that the need for the governor obtaining the previous instructions from the President before promulgating an ordinance containing provisions which, if embodied in a bill, would have required the previous sanction of the President for its introduction in the state legislature would disappear. While dealing with Article 254(2), we have pointed out that the provision is unnecessary and that it may be omitted. Consequently, in the proviso to Article 213(1), the condition that the previous instructions from the President should be obtained by the Governor before the later promulgates an ordinance containing provisions which, if embodied in a bill, would have been reserved for the consideration of the President is no longer necessary. We have also suggested the total omission of the provisions relating to the reservation of state bills for consideration of the President, except in cases falling under Article 288(2). The proviso to Article 213(1) may be so modified as to restrict it to cases falling under Article 288(2).